also very excited that I get to recognize one of the members of that organizing committee who is going to be leading our first session today. And so Dr. Anne-Marie Mazza of the National Academies of Science, Engineering, and Medicine is the director of the National Academy's Committee on Science, Technology, and Law. She currently serves as the study director for the joint NAS Federal Judicial Center Reference Manual on Scientific Evidence, which is provided to all federal judges. From 2021 to 2022, she was detailed to the White House as executive director of the President's Council of Advisors of Science and Technology, or PCAST, where she established several initiatives on semiconductors, public health, extreme weather, and the bioeconomy. And then one of my favorite parts of her bio is that she's an elected fellow of the AAAS. So I'm going to ask Dr. Mazza to come up here and get you started. I hope I was brief enough. Thank you.
Good morning and welcome. A special thank you to our colleagues at AAAS, especially Teresa, Alan, and Joel, for inviting the National Academies of Science, Technology, for inviting the National Academies Committee on Science, Technology, and Law to partner with them on this event, and for the fabulous job they've done in planning it. I am delighted to introduce Jennifer Mnookin, who last year at about this time became Chancellor of the University of Wisconsin-Madison. Prior to leading the UW-Madison, Jennifer served as Dean of the UCLA School of Law, where she helped strengthen the school's academic excellence, increase both diversity and the academic strength of the student body, and built new programs in areas ranging from law and technology to human rights. Chancellor Mnookin is one of the nation's most cited legal scholars in the area of evidence law. She has served on many national committees examining forensic science, including co-chairing with Judge Harry Edwards, a senior advisors group for PCAST when they undertook their review of forensics. She also is a dear colleague and friend to the National Academies, serving as a member of the Committee on Science, Technology, and Law, and as an external reviewer of our 2009 Forensic Science Report. Currently, she is co-chairing a study for the Academy on facial recognition technology that will be issued later this year. Jennifer holds degrees from Harvard, Yale, and MIT. I can think of no better person to start us off this morning. Please join me in welcoming Chancellor Mnookin.
Thank you, Anne-Marie, for that very kind introduction, and it's an honor and a pleasure to get to share some opening remarks for this really terrific two-day conference on such an important set of topics. I'm really delighted to be here and looking forward to the conversations, both the ones that take place here on the podium, as well as the conversations that take place in the hallways and in more informal settings, where we can work on that excellence and collaboration that was just mentioned. So I am going to make some framing remarks that I hope will set the stage. I realize that there are some people in this room who know an extraordinary amount about these topics, and others who may be here because they're in the process of learning about them. But I want to walk you back to the date of June 28th, 1993. It was a typical June day here in DC. High of 86, you know, a little bit humid, as can be the want. And I was in Washington, D.C. at that point. I'd finished 2 years of law school, and I was 1 year into my PhD program in the history and social study of science and technology. And so I knew that I was interested in the intersection of science and law, and I was trying to learn as much as I could about that. I was working as a summer associate for a DC firm, Mayer Brown and Platt, as it happens, and I was already interested in this intersection of science and law, and so I was certainly well aware that the Supreme Court was hearing a potentially major case on the issue. At the firm, lots of people were interested in the case, and when the opinion came down that morning, One of the mid-level associates suggested that a few of us try to take a quick look at least at the opinion before we all went out to lunch, and that we should get together to talk about it. And that's what we did. And so this lunch conversation of more than 30 years ago, just over 30 years ago, has stuck with me ever since. And I'm going to describe it in a little bit of detail because it frames some of the ways that we've been wrestling with Daubert and its meaning and its effects ever since. Now, as probably almost everybody in this room is well aware, the formal question at issue in the Daubert case was whether the federal rules of evidence incorporated the Frye standard or whether they superseded the Frye standard for admissibility of expert evidence. The Frye test came out of a 1923 case in the DC Circuit involving a lie detector based on measuring systolic blood pressure. And the DC Court of Appeals had concluded, and I quote, "While courts will go a long way in admitting expert testimony deduced from a well-recognized scientific principle or discovery, the thing from which the deduction is made must be sufficiently established to have gained general acceptance in the particular field in which it belongs." And so Frye set up this test where the question was, is this generally accepted by scientists in the relevant field? Now, much has been written about Frye and how it worked and how it operated, and the fact that there can be sort of strict Frye and lax Frye, who counts as the relevant expert community, what counts as generally accepted. Does it just have to be generally accepted by the practitioners of that specific thing, or do we need to look at a bigger group? So there's lots of questions around the Frye test, and in practice, in many instances, the Frye test wasn't much of a standard because many courts would find that it was enough if the expert testified. I'm a member of this scientific community and I say it's generally accepted. And so that in practice was often seen as enough, though not always. And so the question on the table in Daubert was whether the federal rules of evidence, which make no mention of Frye, incorporated Frye, superseded it, or what? And the court concluded on that June day that the federal rules of evidence superseded the Frye test. Now on that, everyone at my June lunch agreed. The court was quite clear that the Frye test was no longer the law of the land for thinking about expert testimony in the federal courts, if ever it really had been. But what did Daubert say and what did it mean? One of the lawyers at the table, I'm not going to name names, but this person is now actually still at Mayer Brown, a very well-respected partner, was entirely convinced that Daubert was going to lead to courts admitting substantially more expert evidence. One of the other lawyers vehemently disagreed, saying that the case was likely to substantially restrict whether experts and their testimony ever got to the fact finder. And they each had some plausible textual support for their point of view. The lawyer who thought, you know what, this is just going to open the doors further to admissibility, could point to language in the opinion, more or less saying directly and explicitly that this was intended to be more permissive than Frye. The case, for example, says, quote, "Given the rule's permissive backdrop, and their inclusion of a specific rule in expert testimony that does not mention general acceptance, the assertion that the rules somehow assimilated Frye is unconvincing. Frye made general acceptance the exclusive test for admitting expert testimony. That austere standard, absent from and incompatible with the federal rules of evidence, should not be applied in federal trials," Blackmun's opinion wrote. So no more with Frye's austere standard. And the rules are supposed to have a permissive backdrop. The case also says, and I quote, "A rigid general acceptance requirement would be at odds with the liberal thrust of the federal rules and their general approach of relaxing the traditional barriers to opinion testimony." So again, we're trying to relax the traditional barriers, and there's a liberal thrust here. And so the one lawyer was pointing to this language and saying, see, the Supreme Court saying Judges should be really permissive about all of this. Another attorney at the table strongly disagreed. And he said, yeah, they're saying that, but that's just window dressing. Really, the court here is going to, this opinion is going to have the consequence of significantly restricting expert evidence. Because yes, they use language like austere and that this is supposed to be more permissive, but the court also makes clear that judges are now supposed to assess the expert testimony substantively and determine whether it passes muster. And this attorney pointed to language in the opinion like, in order to qualify as scientific knowledge, an inference or assertion must be derived by the scientific method. Proposed testimony must be supported by appropriate validation, i.e. good grounds based on what is known. In short, the requirement that an expert's testimony pertain to scientific knowledge establishes a standard of evidentiary reliability. And in an oft-quoted phrase, the opinion said, in a case involving scientific evidence, evidentiary reliability will be based on scientific validity. So now this reading of the case is saying to courts, you've got to look at this. You've got to take a look, and to decide whether it's reliable legal evidence, you have to decide if it's scientifically valid. And so this attorney was emphasizing that this opinion was giving judges a clear responsibility to assess scientific validity, to play what we now regularly call a gatekeeping role, a term that is used a couple of times in the opinion, but not so often as to make it completely obvious on that June day when we were talking about it, that the gatekeeping role would be sort of a frame for how we came to understand it. Still, the second lawyer was completely convinced that the approach taken in this case was going to raise the bar to admissibility. And his confidence in this was also strengthened by some of the currents that were swirling around the case that we also talked about a little bit at that lunch. These were some of the anxieties about what was often termed junk science in the courtroom. They'd been stated perhaps most forcefully, if perhaps a little bit polemically, in Peter Huber's 1991 book, Galileo's Revenge, Junk Science in the Courtroom, which argued that the failure to prevent shoddy and spurious science from getting to fact finders was leading not only to unjustified legal outcomes based on really lousy science, but was having a significant effect even on the American economy by driving good products from the market, preventing innovation because people were afraid of lawsuits, and even taking life-saving technologies from the market because of unjustified findings of liability based on erroneous scientific claims. Now, interesting, that context is entirely unmentioned in the Daubert opinion, but it is an important part of understanding the backdrop of what got us there. So as we talked about the case at lunch, a third view emerged a bit collectively from our conversation. And this view was one that I, as a budding student of science and law, and their fraught but absolutely critical spaces of intersection, found pretty compelling, and I think it still is. One of the challenges around Daubert, and why we're still thinking about what it means and its effects 30 years later, is that it was something of a something for everyone opinion. It gave credence to both of those first views that I just described, and more than that, it also clearly did ask judges to play some kind of gatekeeping role and to assess whether the science at issue was adequately valid and reliable. But it went on to offer such a variety of ways to potentially do that, that in practice, it might leave the answer to whether evidence did or didn't withstand scrutiny pretty open-ended. What did the opinion say about how the courts were to assess validity? Well, the court said it was not going to provide a definitive checklist, and then it proceeded to provide well, something of a checklist. And what was on that checklist? It was also clear that this wasn't exhaustive and that other factors could come into play. Well, first was, could the scientific claim be tested? And had it been tested? The court also gestures at falsifiability and Popper. So, again, there's a little bit of lots of different philosophy of science ideas at work in this opinion. But the core idea was that, has this been tested? Science is supposed to be about testing hypotheses. Could this be tested? Was it testable? And had it been tested? So that was one factor. Had it been published? Not the sine qua non, but relevant. And was it otherwise subjected to peer review? That's, again, part of the scientific process for producing knowledge. Is there a known rate of error or a potential rate of error? Are there standards governing the technique that presumably are themselves validated and appropriate? And is this generally accepted by the relevant scientific community? Yes, the Frye standard was back, still available as a criterion, just not an exclusive one. So this was a pretty broad set of criteria that judges could potentially look at for assessing this, and a set of inquiries that probably weren't going to come too naturally to judges, given that most judges don't have deep expertise in or foundations in science. And the court didn't give, or even really try to give, any guidance about whether some of these criteria should be more important than others, or about how well you had to do in applying these criteria to be adequately reliable or adequately valid as science to produce legal reliability. So what we had, and what we did all come to agree upon at that lunch, as I remember it, was a case asking judges to look at a concept that probably wasn't going to be easy, clear, or comfortable for them, along with a pretty flexible, multi-pronged test that also wasn't even an exclusive test, that was going to be challenging to apply, and that also, as General Electric versus Joyner would make clear a little bit later, as part of the trio of really core cases in this space, that these determinations would be governed on appeal by an abuse of discretion standard. For the non-lawyers in the room, that's a pretty low standard. That's the appellate judges isn't asking, is this a decision I would make, but rather, did the trial judge really get this wrong? Did they abuse their discretion in making this determination? And so judges on the ground were likely to have a fair bit of flexibility in how they went about applying this multi-pronged, somewhat ethereal set of tests. So in many ways, what Daubert did was make more explicit that judges had a gatekeeping responsibility, while in practice giving them enormous flexibility about how to exercise it. I take you back to that June day because I think it's kind of interesting to see that it wasn't really completely obvious to a set of, pretty capable people what Daubert would do and what Daubert would mean. It wasn't sort of crystal clear on the face of the opinion what its consequences would be, but that we did all understand at that lunch that this was probably a pretty important case. And so there was a sense that this was going to matter, but not a lot of clarity about exactly how. I want to turn now to a few of the sort of general frames of what I think we've seen over this past 30 years. This is pretty broad brush, and some of these are contestable. So I hope over the course of today and tomorrow that we get the chance to explore a little bit more, and perhaps some of you will say, that one's all wrong, and this other one maybe has some credence. But here are some of my perspectives on what hath Daubert wrought in some ways over this past 30 years, and what hasn't it changed. So first, and perhaps foremost, I think the biggest effect and impact of Daubert is actually salience around these issues of expert evidence in court, their importance and their complexity. that what this opinion and its progeny and everything else has done is create the space for organizations like the AAAS to get more involved, the NAS, so many others, and to care about these questions about science and law and how they intersect. Daubert has led to substantially more engagement with this question of what should be admissible in court in the name of science and expertise, and how courts should grapple with that question. There's been more academic scrutiny. A number of us, including a number of us in this room, have spent good parts of our own academic careers focusing on this set of questions. There have been many more discussions, more gatherings, more creation of projects like the reference manual, more trainings, more opportunities to look at these issues. There have also been many, many more pretrial hearings, right? So Daubert hearings have become a procedural staple, certainly on the civil side, and to a lesser extent, but present on the criminal side as well. And so it's had real procedural effect on where and how judges think about this. There's also been more appellate engagement, many more appellate cases grappling with the questions of admissibility. The evidence curriculum at the law school level has been impacted too. I don't have proof of this, but I would say that before the Daubert opinion, if you pulled out your typical law school evidence syllabus, I would guess that the amount of time devoted to expert evidence was probably, I don't know, I would guess that the modal amount of time might have been 0, and some people maybe gave it a day or so. I would say that now it would be pretty unusual in a 4-credit evidence class, and probably even in a 3-credit one, not to at least give some attention to expert evidence, and that some folks teaching evidence would now give it a solid week of the curriculum, and there's definitely more law schools that now have specialty upper-level classes focusing on these questions. There's also more conversation about the need for people in the legal system to be trained in science. Not all of them, but that we have, that it's a value to have within the legal system a set of participants, and not just, say, for patent law, right, that actually have training in both languages, if we can call them that. And so I think the biggest thing that Daubert has done over this past 30 years is get us all to talk a lot more about these challenges about scientific expert evidence in the courtroom. And that in some ways, that heightened salience and focus and space of engagement is its biggest contribution. Now, I do think that Daubert also did change the judge's role vis-a-vis scientific evidence to a degree in federal courts and in many of the states that adopted Daubert, although interestingly, to some degree, even in states that didn't adopt Daubert. There's no question that some states that stayed with Frye, you still saw judges paying more attention to the question of admissibility of expert evidence than they had previously, which goes back to that salience point. But Daubert did shift, in some ways, the frame, the epistemic frame, we might say, for what a judge was supposed to do vis-a-vis expert evidence. If you take the Frye test seriously, it's still a proxy question. The judge was supposed to ask, what does the scientific community think? The judge wasn't really supposed to make an independent decision about validity or reliability, but rather look to experts and ask, what does this appropriate group of experts say about the evidence? And so it was designed as a second-order inquiry. The judge was asking, what does this other group, again, we can debate what group, how much general acceptance, who counts as being a member of the appropriate group, but the query was a second-order one. By contrast, Daubert created, with its checklist and then going beyond that checklist, a much more complicated set of inquiries that were a mixture of proxy criterion. Some of them were still proxy criteria, right? Like general acceptance is still there, and looking at whether it's been published in an appropriate place, looking at whether it's been peer-reviewed by others, those are still second-order criteria where you're looking at what did some other people say about this. But now judges were also invited to bring their own abilities to the question of validity and reliability, and to look at whether it had been tested, and presumably whether it had been adequately tested, to assess the error rate, and the overall inquiry was now one for them, that they were supposed to use this set of criteria to assess scientific validity as best they could. I think this is worth naming because this is part of what's tricky. It also raises, it connects to an even bigger question that was explored very well back in 1993, the same year as Daubert, by Ron Allen, who's sitting in this room, in one of the articles that I love referencing, and so I'll do it again here, which looks at whether our fundamental conception around expert evidence is supposed to be about deference or it's supposed to be about education. Is the idea that we're trying to bring in expert knowledge to educate the fact finder to make their own decision? Is the goal that the fact finder gets to be sufficiently sophisticated to say, all right, I understand the issue and I side with scientist X? Or is the goal to bring in experts and ask the jury or the judge as fact finder to defer to the expert that they believe is more authoritative, more worthy of deference? This is an issue at the fact-finding level, but it's also in some ways an issue at the admissibility level, right? Are courts supposed to reach their own conclusion, to be educated enough to make a determination of validity? Or are they using proxy criteria to try to decide whether they should be deferring to the scientific community's judgment about whether this is adequately valid or reliable? And my point here is that Daubert didn't give us a clear answer. It did some of both. And that's part and parcel with what we've done as a legal system vis-a-vis expert evidence before, during, and since Daubert. That is, we're not really clear on which of these is even the philosophical framework that we're trying to bring to the question. I mean, at some level, we might say that the fantasy version is education, but we also probably know it's a fantasy. The whole reason we use experts is because the knowledge goes beyond the ken of the ordinary fact finder. And so is it plausible or realistic for a jury, a member of a jury, a judge as a decision maker, or a judge as somebody making a legal determination, to actually understand this well enough to make a truly valid, epistemically valid decision? So the point here is that that the query shifted from a pretty clear set of proxy criterion to something much more complicated that might in some ways make more sense philosophically, but also might actually be impossible, right? We might not want courts to just defer to experts, especially given something I'll say at the very end of my remarks about partisanship. But we also might not have faith that the judges will actually be terribly good at this. Okay, so that's number two. A sub-point of number two, and I'll just mention this one briefly, is that Daubert didn't say anything about how a court is supposed to think about multiple items of expert evidence. In some ways, it's going from a look at Fry in practice also often amounted to looking at the speaker and his or her qualifications. Fry didn't have to be that. There's a way to make Fry stricter than that. But in practice, Fry often amounted to the judge saying, well, this expert's qualified, and they say this is generally accepted, and so that's enough. And so really looking at who is saying this, and do they seem like somebody who has the bona fides to be able to say this kind of thing. Daubert was a shift more to the substance The expert still has to have adequate qualifications to qualify as an expert, but that standing alone isn't enough when we're actually looking at the items of evidence. But what if there's a bunch of items of evidence that relate and you're trying to aggregate or think about together? Should the court assess those items individually, bit by bit by bit, or should they be able to be holistic and to take more of a weight of the evidence approach? If there are 5 fairly flawed studies, all suggesting that a particular chemical might create an elevated risk of causing cancer, should a court unpack those studies one by one, and if they understand the flaws in them, throw them out one by one, because no study is itself adequately reliable? Or would it be legitimate for the court to say, well, each of these studies individually has flaws, but they actually have relatively different flaws, and they're all pointing in the same direction as a conclusion. And so we could take a weight of the evidence approach to say that there is enough here to suggest the possibility of there being a scientifically valid claim about causation. And if an expert is aggregating, if the expert is saying, my expert opinion is based on this collection of items, how should the court think about that? How should the court unpack that? Frankly, this is a hard question for scientists, right? Scientists don't have completely shared or clear criteria for doing precisely that. We have mechanisms, including consensus reports, including, Cochrane studies and all kinds of other places where we think about aggregating data, but there aren't rules about it. And there's actually even some methodological disagreements about how to do that. So if this is a place where scientists wrestle with this, how in the world can courts do it well or effectively? Is that going to be plausible? And are there dangers on both sides? Are there dangers that judges are going to look at each item and say, not valid enough, not valid enough, not valid enough, not valid enough, and sort of miss the forest for the trees, when in fact it might be quite scientifically legitimate to say, yes, these studies are flawed, but they are sufficient in number and approach to reach a conclusion based on them in aggregate? Or is there also a risk that the court will just take the expert's conclusion that says, on the basis of these studies taken as a collective, I reach a conclusion when in fact scientific authority would say that there wasn't an adequate basis? So I'm trying to give you a flavor for how Daubert is actually asking courts to do really hard things. And so we shouldn't be terribly surprised when it turns out those are probably a bit too hard. That's not necessarily a failure of the individual judge or even the judicial system. It's a more structural tension in the problem of what we're asking folks to do. Okay, so far, more salience and changing judicial role vis-a-vis scientific evidence may be in many ways appropriate, but also really hard to do responsibly. Number 3, and although this is contestable, I would say that on the civil side, there is decent evidence that as a general matter, Daubert did raise the bar for admissibility for a number of kinds of expert evidence, especially vis-a-vis proof of causation in complex torts cases. There have been a number of empirical efforts to look at the effects of Daubert, and they've actually been some find that there really has been, some find that there hasn't, it depends how you look. I'm not going to go into that here and now. But I think that there certainly have been a lot of high-profile complex torts cases where judges have been more aggressive about excluding plaintiffs' claimed expert testimony than what we tended to see prior to Daubert. And so Daubert gave judges a set of tools that they could use for exclusion when they saw fit. And on the civil side, especially around causation evidence in these issues, there have been many judges who have taken these tools and run with them. This is a pretty important area because in these cases, exclusion is often case dispositive. If the plaintiff's expert evidence on causation is excluded, the defendants win summary judgment. The plaintiffs can no longer prove something that they absolutely need to. So if it is junk science, if there is really no valid evidence of causation, this is a good thing, right? This is what people like Peter Huber were very worried about, and it's a terrific thing if judges are preventing these trials from getting to juries, where there is certainly a risk that juries will be persuaded by the power of the harm, and not also probably mostly scientists themselves, and not necessarily as focused on the adequacy of proof of causation as maybe looking at just harm and maybe negligence, right? So this is, on the other hand, if courts are sometimes ever too aggressive about excluding, and the weight of the evidence description that I was trying to have a few minutes ago suggests the ways that they might be, this could lead cases to never get to trial that perhaps should. And this can especially be a risk when there's areas that might have a modestly elevated risk of causing harm, where for the defendants to lose all the cases is probably the wrong outcome, but for them to win all the cases and never have to face trial might not be the right outcome either. So this is a complicated issue that I'm sure we'll be coming back to, but the point here is to just sort of say that if we look with 30 years of experience, I do think there's been this impact on the civil side that is genuine. And remember, summary judgment is, of course, de novo, and with the evidence considered in the light most favorable to the party against whom judgment was granted. But if the plaintiff's causation evidence gets excluded by Daubert, that's evaluated on appeal under the looser abuse of discretion standard, and so it's unlikely to be overturned. On the criminal side, we see a pretty different story. Overall, I would say that Daubert has led to more engagement and more scrutiny of forensic science evidence in particular, but it hasn't done very much overall to shift the terrain of admissibility or to raise standards with respect to many kinds of long-used forensic science of pretty dubious scientific validity. There have been quite a few Daubert challenges, but even when they reveal that the scientific foundation of the technique at issue is much weaker than might have been expected, for the most part, and there are certainly exceptions, but for the most part, courts have had a strong tendency to admit the prosecution proffered scientific evidence anyway. Sometimes, as a function of this salience, engagement, Daubert hearings, etc., there have been modest changes to the way the experts are allowed to testify. There's been some shifts from wildly overstated language to more curtailed ways of talking about what's being introduced. So to take, say, fingerprint identification evidence, latent fingerprint evidence, it's no longer typical to see experts asserting that the error rate is 0, or that that they think that the field or they have really never made errors, or that they're 100% certain, or that this fingerprint can be adequately matched to this person to the exclusion of everybody else in the world, living, dead, or everything else. Those claims have been somewhat scaled back in many instances, but restrictions that are likely to be understood differently by juries or exclusion has been extremely rare. And so it's just interesting to see this divergence between the civil side, where we've seen pretty dramatic willingness in a variety of instances to exclude case dispositive evidence, and on the criminal side, we have seen that far, far less frequently. What we have seen on the criminal side is more willingness, some of the time, to at least take a look. But even there are many courts that sort of say, we heard a challenge to this last year over there, we're not going to hear it again. And we've also seen some resistance to taking a broad view of who could count as a legitimate expert to testify about such matters. So where I want to conclude here, having described these 4 general framework effects, that we have more salience, a changed judicial role, some real consequences that are even outcome dispositive on the civil side, and many fewer of those on the criminal side, is that what Daubert hasn't done much to change, but I don't think it could have. So I don't mean this as a critique of the opinion exactly, but I think it's worth saying, is that there's core structural challenges around the use of expert evidence within a lay adjudicatory system that I don't think a standard can actually do that much to solve. I've already hinted at this a little bit in my discussion of deference versus education and the fact that we're not even sure what we're looking for. But I name, in conclusion, sort of 2 more structural challenges that we wrestle with. And it may be that all we can hope for is to wrestle with this and to collaborate and to engage and to talk about it and to continue to try to debate this for the good of justice and the use of accurate information in court. And these 2 core structural challenges, as I see them, are partisanship and epistemic competence. And I've written about this elsewhere, and I'm going to be very brief here. We have a system of party-called experts. Parties get to pick who they bring into court. They pay them. They often pay them well. And they get to pick who they want. And so parties get to pick the people that they think are going to be persuasive with the judge and or the jury as fact finder. At the extremes, you can get charlatans. At the extremes, you can get people that the mainstream scientific community would say, not this person, that's ridiculous, that has no validity. And sometimes maybe Daubert and all of this process can help courts identify those charlatans. But you also get, forget the charlatans, you get when there's real debate and disagreement, you're going to pick experts that take your view, that share your view. And you're going to pick the experts, you're going to try to pick the experts that can be most persuasive, that that view is the right one. And so what you get is, and then the process, we're all human. So good people who are trying to testify appropriately, they still start to feel like they're part of a team. They're often getting paid and paid well, and they're part of the process. And that's not necessarily a set of dynamics that are going to encourage kind of disinterested perspectives, nor are attorneys necessarily going to choose the experts who are going to be most balanced about how they're engaging with the material. And so partisanship is a structural issue. And this goes way back, way before Daubert, even before Frey. You can find all over 19th century engagements with expert evidence, people being very frustrated that you're both setting juries to decide when doctors disagree, as Learned Hand famously put it in a turn of the century article, and that what you get in courts are liars, damn liars, and experts, right? That's also a direct quote from a 19th century complaint about how badly this whole system was working. And so when you've got party-controlled is a little too strong, party-called, party-selected, party-engaged experts within an adversarial system, that is probably not necessarily a great model for how to circumscribe the range of legitimate disagreement. And nothing about Daubert has much changed that. Yes, courts have a set of tools that they can use and sometimes do use, whether it's special masters or court-appointed experts, but these are rarely used. And this party-called framework is very much dominant, and it raises partisanship challenges that we have not even begun to solve. And then the second problem is a structural problem of epistemic competence, right? No matter how well-intentioned a smart, creative judge is, they are not going to be a full citizen of the scientific form of knowing that's at issue in the case. even if they're a PhD in science, actually. I mean, then they might know something. I mean, you know, a PhD physicist who becomes a judge will know one set of things, but not another, right? And so there's going to be places where judges as decision makers and juries as decision makers they're not going to have full epistemic competence for the questions that we're asking them to decide. I don't really think there's a full way around that issue. I don't think there's any great solution. I don't think, sometimes people call for science courts or expert juries, but I actually don't think those really solve the problem. I mean, they might solve it in the most egregious cases, but I think that there'll always be a lingering problem of epistemic competence in this system. And so we can't solve it, but we can name it. And we can recognize that one of the big contributions of Daubert and its progeny is to create the spaces to talk about exactly these issues. We won't resolve them. They're going to keep recurring, but through dialogue and collaboration, we can try to find methods and mechanisms for engaging across and for trying to recognize when these tensions and problems threaten to be a genuine risk to doing justice and reaching fair outcomes. Thank you for this opportunity to talk to you, and I look forward to the conversations through the rest of the day. We still have a few minutes for questions. Okay. Trying to leave 10 minutes for questions, but clearly that didn't quite work.
So we have one question from our virtual audience. How does Daubert help the judge make findings if experts contradict each other?
It's a great question, and it's a challenge. And so really, what Daubert does, I don't have a mic, well, there, now I do. Is it on? Push the button. Now? All right. So how does Daubert help judges make decisions if experts contradict each other? So first of all, what Daubert really is about making determinations in advance of trial about whether the evidence is going to be heard at trial at all, right? And so that question describes one of the tensions, because if courts are super aggressive about their application of Daubert, and so they exclude all of the expert testimony on one side as being inadequately valid and reliable, then sometimes that leads to the end of the case, summary judgment. Other times it means that at trial, only one side has expert evidence on a relevant point. And judges shouldn't invade the province of the jury. And so if there's a legitimate disagreement of fact, both of the experts or both sides' experts should be getting to the jury or the judge as fact finder to be able to make a determination. But think about that. That's a really, that's a challenging line to draw, because can a judge say, well, I think this expert seems like their views are more valid than this other expert on the other side, but both meet the minimum validity standard such that they should be heard. We don't want the court to simply be deciding in advance of trial which expert is more credible or more valid. If both reach a minimum threshold that they're valid enough to be admitted, but that can mean that a court is allowing evidence, both A and not A, and then if they do that, Daubert really has nothing to say at trial about who the jury should believe. So that's a quick answer.
Hi, thank you so much for that really interesting talk. I'm Sandra Chom, I'm Vice President of the Environmental Law Institute, and I just wanted to ask you a question about the aspect that you outlined toward the end, that since Daubert, in civil cases, there has been a trend of much more case dispositive evidence being thrown out at the summary judgment stage. And I'm wondering if you know how much detail there is in that research. Has anybody looked at, are there certain topics or certain kinds of information? Is there a distinction between a study versus consensus science reports and any of that kind of detail? Thank you.
Thanks. There is some research on this, and I can sort of direct you to some of it afterwards. I guess what I would say as a gross generalization is that in cases involving mass toxic torts, there have been many judges who have required something of an epidemiological foundation in order to make a claim of causation in a more aggressive way than they did prior to Daubert. There are exceptions to that, right? So since we have a really distributed legal system, any generalization, you're going to be able to find some judges who don't do that, and where that withstands scrutiny too, because Daubert is a pretty open-ended, flexible test, although also on appeal, you've seen some appellate courts be a little bit heavier-handed about this on the civil side than the criminal side. But I guess I would say that that is one area where we've seen and where plaintiffs' attorneys have had to wrestle with shifting and elevating standards for what is needed to be proven.
Jennifer, we're going to take one more question for the audience. And then...
Hi, I'm Valerie Hans from Cornell Law School, and just really enjoyed your framing remarks today. I wonder if, I'd love to hear some more reflections from you about this basic distinction you saw in the impact of Daubert on civil versus criminal cases. I mean, is it just that defendants in civil cases have more money and incentive to go out there and find research evidence that'll support and really push on causation issues, for example, whereas that's not always the case in criminal cases? Or are there just different issues that seem to come up more in civil cases, especially causation, like you were just saying?
So I think my quick answer is yes, and yes, and yes, and yes. So I think it's much more common on the civil side to have matched resources. Obviously, often you don't, but often you do, right? So you often get parties where both sides are in a position to invest substantially in the process, whereas on the criminal side, you often get indigent defendants and huge variation about whether public defenders' offices have the resources to support bringing in experts at all. And even in the non-indigent defendant side, you get a lot of cases, especially those involving forensic science and, as opposed to, say, white-collar side cases, where you often don't have matched resources nearly as often. You also traditionally have many more judges who are former prosecutors than former defense attorneys. That is beginning to shift a little bit, but I think just in terms of where people came from to the bench, that's another factor. Another factor is that a lot of these kinds of forensic science were long used, and so the idea of unsettling the apple cart about kinds of proof that have been used extensively over time feels different than taking up a causation claim around something that feels a bit newer. So I think that's another dynamic. And in fact, Fry talked about novel scientific techniques. Daubert made clear that that's not a limitation. I think yet another element is that many kinds of forensic science don't seem like rocket science, right? They feel like things that ordinary people can kind of understand. So, we know we've got like little marks on our fingers. We may not be fingerprint experts, but it's a category of things that doesn't seem extraordinarily abstruse or impossible to get your head around. And so I think that too leads courts to be more comfortable with I'll let it in for what it's worth, and to believe that the fact finder can make some kind of assessment, even though what really may be at issue are questions of scientific validity that aren't going to necessarily be comfortable or in the realm of knowledge for a fact finder. But I do think the kind of literal visibility of some of these kinds of evidence probably plays a role as well. And then I guess I also think that broader cultural beliefs about these kinds of evidence probably play some role too. I mean, fingerprints were treated as the gold standard, right? Wildly dispositive. Like, what? There might be issues? And so when things get to court, they don't get to court in a space separate from or outside of broader cultural consciousness about what we find persuasive or what we think is likely true. And so I think that probably impacts how it's understood on the criminal side as well. Thanks.
Jennifer, just one final question I'd be remiss in not asking. Judge Harry Edwards, who co-chaired the 2009 forensic study, who also co-chaired with you the science advisory group at PeaceCast when they were looking at forensic science, has often said that you cannot expect lawyers and judges to solve the forensic science problem, that it's up to the scientific community. Well, we're here at AAAS. This has been co-sponsored with the National Academy of Sciences. The National Science Foundation has been one of the funders. I'm just wondering if you could say to the scientific community, how can we become more engaged? What does the scientific community need to do to move forward in this space?
It's a great question and a hard one, because the scientific community has tried to do a set of things including AAAS has tried to do some things in exactly this space, so has the National Academy. And what has been striking is the way that judges have, with some frequency, been willing to kind of gesture at these interventions from the scientific community, but not take them that seriously, right? So the National Academy Forensic Science report, said incredibly loudly that there was a problem here, and courts referenced it, but basically nonetheless ignored it. Now that report didn't come out and say to judges, you would be remiss in admitting this unless or until these things happened. It kind of went up to that line but didn't go quite there. And many courts chose not to read it that way. The PCAST report tried to be a step more aggressive on that point. And again, courts referenced it but didn't take it all that seriously. The AAAS has done some great work looking at some particular kinds of forensic science and assessing knowledge gaps. But the courts have been relatively resistant to the idea that they need to defer to the scientific community in this space or treat these determinations as dispositive or transformative within the legal space. I don't want to sound, there has been some modicum of change, and we're starting to see in parts of the forensic science community more interest in these questions. We've also started to see, perhaps especially maybe with firearms evidence in the last couple of years, a set of judges being more aggressive in their engagements. And we've seen in something like bite marks now, I think, a pretty widespread understanding that bite mark identification evidence is junk, to use that word, and shouldn't be used. But the work that produced that consensus largely did not take place in court or through admissibility determinations. It took place in external, scientifically linked spaces and forensic science commissions and work of the Innocence Project and in other kind of adjacent arenas. And so this isn't a terribly happy story on the question of whether admissibility hearings and Daubert and an approach to thinking about science in court can be an effective mechanism for bringing about change. Thank you.
On that note, please join me in thanking Jennifer.
Thanks very much.